Good afternoon, everyone. I'm logging in from Korea and the eastern part of the world. And good morning to you all viewing from the west. My name is Kelly Yi, Chief Representative of HKIAC Seoul office. To briefly introduce myself, I am a US and England and Wales dual qualified attorney and have been with HKIAC for over 2 years now. Prior to joining HKIAC, I practiced international arbitration at an international law firm and also as an in-house counsel for a Korean company. During my various roles, I have worked on numerous hearings and worked with many experts in the fields of law, quantum, delay, and more. They play a critical role, as you know, in assisting the tribunal with specialized professional expertise in areas such as technical assessments, market evaluations, financial analysis, calculation of lost profits claims, assessments of defect malfunctions, reasons for delay and disruption, and to just name a few. From a client's perspective, not only is it critical to the case outcome, but experts can be a costly burden as well. It is a very important topic, and we have here 3 arbitration specialists to discuss this important topic of role of experts and how to manage them. First, we have Matthew Gearing, QC, a partner at Allen & Overy's Global Arbitration Group. You all know he's a leading arbitration practitioner and has acted in large numbers of complex and high-profile arbitrations around the world, both commercial and investment treaty arbitrations. He was appointed Queen's Counsel in February 2014 and is also a solicitor advocate qualified in Hong Kong. He acts both as an advocate and as an arbitrator in international arbitration matters. He was also a chairman of HKIAC from 2017 to 2020. And he also serves as a co-chair of LCIA Young International Arbitration Group and is also on Prime Finance's panel of dispute resolution experts. Second, we also have Jane Evans as a panel speaker, who is a dual qualified barrister and chartered accountant. Very unique background. And Jane is a distinguished international arbitration practitioner who also acts as lead or co-counsel on the case and also as an arbitrator herself. She is ranked in the Legal 500 in chambers for energy dispute, construction, and international arbitration matters. Lastly, but not least, we also have Myung-Ahn Kim, a partner, senior foreign attorney who co-heads Yun and Yang's international arbitration and dispute resolution team. She practices primarily in the areas of international dispute resolution, shipping, commodities, aviation, insurance, and trade. And prior to joining Yun and Yang, she has experience working for another Korean firm and also worked at an international law firm in Singapore. Ms. Kim has successfully represented a number of domestic and international entities in ICC, HKIAC, DIS, LMAA, HKIAC, and KCAB arbitrations. As you have just heard, all our speakers are very well qualified, and I am very excited to have our speakers share their experiences and perspective on this important topic. Now, as to the format, our individual speakers will each present on their topic with the slides you see on the screen, which will be followed by a panel discussion on the topic presented. This process repeated for each speaker, and we will end with a Q&A session. So please provide any inquiries or questions you may have in the Q&A box on the screen as you follow us on this webinar, and we will deal with it at the end of the webinar. I look forward to this interactive engagement, and now I will pass along to Matthew to kick off the presentation with this section. Sorry, let me pull it to, there you go. Thank you, Matthew. Matt, we can't hear you. I think you're on mute.
Hello.
There we go.
Good morning. Good morning, afternoon, and early evening for a few of you. It's obviously a pleasure to be talking, particularly, of course, at an HKIAC event, an institution that's obviously extremely close to my heart, as a lot of you know. I'm going to just kick the ball off, or start the ball rolling with a few observations on experts, a few personal observations really on experts in the context of international arbitration, and I will try and weave in the course of the next 10 or 15 minutes a couple of war stories, including a very interesting story involving Korean experts in the context of a recent Seoul-based arbitration that I was involved in. In any event, let me set out the two questions, very simple questions if you like. The first is, who can be an expert witness in international arbitration? And the second is just to explore a little bit, only a little bit, the difference between legal experts and non-legal experts and how one might manage the two. Indeed, as counsel, does one need to behave differently as between a legal expert and a non-legal expert? Kelly, can we go to the next slide, please? Who can be an expert? I've written there somewhat provocatively on the screen, anyone. Of course, that's a glib answer, not entirely correct, but it is true that almost anyone can at least offer their services as an expert. As with much in arbitration, there are no hard and fast rules, or there are a few hard and fast rules. So when you're selecting your expert, if indeed you're going down the route of a party-appointed expert, you will have a bewildering array of choice, indeed as clients do of legal advisors these days. As relatively well-known counsel in international arbitration, all of us, probably, certainly I do, get emails all the time from people offering their services to me and indirectly to my clients as experts. So how does one filter? How does one choose? And how does one work out whether they have the requisite expertise? We'll come back to that point a little bit in a moment. In any event, just on this slide, I just draw two very simple distinctions, and forgive me if they are too obvious, but I think they are the starting points. First of all, of course, when one talks about an expert, one could be talking about a tribunal-appointed expert, i.e. an expert appointed directly by the tribunal and subject to certain rules, giving evidence directly to the tribunal, acting for the tribunal, if you like, and perhaps most commonly a testifying expert, i.e. an expert appointed by the parties, by a party or a group of parties to appear and give evidence to the tribunal. That is the common distinction that you see in the HKIAC rules, and indeed in almost every set of rules that I'm aware of. Of course, the second of those, the so-called testifying expert, is very much the common option, and perhaps more subject for a separate webinar is the question of whether tribunals use the facility of a tribunal expert enough. In my experience, I don't think they do. It's a very underused feature. So when we're talking about experts in this context, the discussion naturally moves quite quickly to testifying experts. On the other hand, I've used a rather inelegant term there, dirty experts. So-called dirty experts or non-testifying experts are experts who simply, and by saying simply, I don't diminish their role, but join the counsel or client team, the case team, if you like, and assist the client and counsel in the presentation of the case, but do not appear as a witness, or certainly do not appear as an independent witness. And in complex cases, certainly in complex construction cases, it would be quite common for a party to have both a testifying expert and a so-called dirty expert. In the second bullet point there, I've touched a little bit on the distinction between party versus tribunal experts, so I won't say anything more about that at the moment. Can we, Kelly, please then turn to the next slide? I said at the outset, somewhat glibly, anyone could be an expert. In fact, there are two qualifications, or there are two criteria that one really needs to look for. The first is, of course, requisite expertise, and the second is independence, or I should have probably written on that slide, independence and impartiality. As to requisite expertise, when you are choosing an expert, it is very common, it's very common to have to make a choice between choosing someone who is a so-called professional or full-time expert. So someone who works full-time, whose full-time job now is really presenting expert evidence to national courts or to arbitration tribunals. And forensic accounting experts would very commonly fall into that bracket. They're people who may have practiced as accountants some time ago, but now practice full-time as experts. That's the first bullet point under one. The second bullet point, which was more common previously, I think it's less common now, is those who are those who act as experts who have another day job, if you like. So people who practice full-time in their main profession and give expert evidence as an incidental function or a byproduct of what they do. Not so relevant to international arbitration, but in the context of medical negligence, it certainly used to be the case, my understanding, that doctors who would appear as experts in the context of medical negligence cases, a lot of them would obviously also continue to practice, you know, during the day in their day job as doctors in the ordinary course. But these days, in the context of international arbitration, certainly in the context of damages and related issues, very often one would be choosing a full-time expert. And then secondly, there is the question of independence. And there are just 2 or 3 points to mention briefly here. Firstly, the safest view, of course, these rules vary jurisdiction by jurisdiction, is that an expert witness owes a fiduciary duty to a client. This takes us all the way back to a well-known English decision that I had a very walk-on part in Prince Jeffrey Balkar and KPMG in 1999, which concerned, as the name of the case would suggest, the role that the accountancy firm KPMG could or could not perform in respect of the brother of the Sultan of Brunei, Prince Jeffrey Balkar, following a role that they had performed in an earlier dispute in which Allen and Overy were acting for certain Bruneian entities. And what effectively that case said was, well, in those circumstances, KPMG, acting as an expert, had acted effectively in a quasi-legal function, or certainly very much closely alongside Allen and Overy as legal advisors. They had therefore, in the course of their duties, assumed a fiduciary duty to the client, and they couldn't essentially turn round and then act for an adverse party to that client. There have been further cases that have explored that concept, a great many of them, and I certainly haven't listed them all here. Of most recent note are 2 cases. The first is A Company in X, which is a decision of the construction court division, if you like, of the High Court in the UK, where an injunction was granted last year to prevent an expert witness from acting for a party in arbitration proceedings concerning a petrochemical plant in circumstances where a colleague of that expert in the same, not in the same actual entity, but in the same overall group, was already acting for the other party in separate but apparently related arbitration proceedings. And I've also listed on the slide a very similar case, although the decision went the other way, in an ICSID case involving Rwanda, Bayview Group in Rwanda, where, as the slide says, the tribunal dismissed an attempt to disqualify Rwanda's legal expert on the basis that, as managing partner of a local law firm, that expert had previously provided legal advice to not exactly one of the claimants, but a related party or a predecessor of one of the claimants on issues relevant to the proceedings. That challenge, unlike the A company v X company case, that the Rwanda challenge didn't work, but the point is essentially the same. Now, in terms of independence, that is essentially to be safeguarded by disclosure, in that almost these days, whatever system you're working in, the expert has to state, as arbitrators have to state clearly, the full details of their relationship with the parties, the tribunal, and importantly, counsel. And this is important because counsel do tend, and I'm no different in this regard, do tend to use the same experts in more than one case. And if you have instructed, for example, a forensic expert in several cases, that would need to be disclosed, and that might be taken into account when considering or seeking to impugn the independence of that expert. Can we, Kelly, can we turn on, please, to the next slide? The short point I want to make here is that I feel, at least, and this is very much a personal comment, that parties are too quick to rush to getting a slew of so-called testifying experts in a case. The ICC, in their recent and I think very good document, The Techniques for Controlling Time and Cost in Arbitration, have said the starting point, it's a simple point, but they've said the starting point should be that there is a presumption against adducing expert evidence to be departed from only in a clear case. What tends to happen is that one party will say that they need to adduce expert evidence in the following disciplines, you know, A, B, and C, and the respondent will then engage experts in those disciplines on a, as I've said in the slide, a so-called tit for tat basis. And then one gets a sort of an arms race of experts. And before you know it, you have a slew of experts. And of course, that will increase costs, not just the cost of the expert, but the cost of all of the lawyers in instructing and dealing with the experts intensively, perhaps before the parties have really carefully focused on the issues that they are seeking to develop by way of expert evidence. Kelly, can we turn on, please? Sorry, the implicit in what I've just said is that I think that tribunals should do more, or certainly should strictly control the scope of expert evidence, so-called testifying evidence. I won't run through all the points in the interest of time, but it is clear that the tribunal has the power to control expert evidence in advance, whether the tribunal is sitting under the HKIAC rules or indeed again under, I think, almost every set of major rules of which I am aware. I've listed on that slide 3 possible tribunal approaches. Very little control, or no control, I should say. The second is defining the scope of expert evidence in advance, i.e. engaging with the parties, but in a collaborative way, not seeking to overly control them, but at least being clear about what expert evidence is going to be adduced later in the proceedings, in what form, and according to what timings and so on. And thirdly is being a little bit more proactive and being bold or brave enough to refuse permission if expert evidence does not appear to be necessary. Now, this final point on this slide may be a point for discussion later, where or common areas where one might wish to adduce expert evidence. Obviously, damages, that I think is the area that comes to light, comes to mind first and foremost when one is thinking about experts. Obviously not where there is only a claim for a liquidated ascertained sum, but wherever, for example, one is talking about trying to quantify a claim for lost profits, for example, whether DCF or otherwise, or invariably one will need an expert. Construction disputes, of course, delay claims analysis, extremely common in construction, heavy construction cases, and of course other technical questions. Thirdly, when one is dealing with complex products, such as, for example, derivatives, certainly something I've come across quite a lot, one may well need an expert to explain in the proper legal context those products to the arbitration tribunal. And I've listed on the slide there an example of a case, Deutsche Bank against Sri Lanka, where an expert gave very clear evidence on behalf of Sri Lanka of the nature of the relevant derivative, which very much assisted the tribunal in reaching its relevant decision in that case. More controversially are the final 2 points. First of all, where experts give evidence on so-called general industry practice, very often as a backdoor way of trying to give evidence, I think, on the construction of the contract. That appears closer to the line to me, but we can perhaps discuss that during the Q&A if helpful. And then, of course, experts giving evidence on points of law. And on that last point, let me just say something briefly. Kelly, can you turn to what I think is my last slide? Should questions of so-called foreign law be the subject of expert evidence? Well, of course, the starting point is that in the true approach to arbitration, there is no foreign law, because international arbitration is, of course, an international instrument, and very often, of course, you'll have tribunals qualified in different systems of law, and sometimes qualified in no systems of law at all. So the strict answer to that is that there is not the distinction between, or there shouldn't be the distinction between a national law or the national law and a foreign law that, for example, one finds in the national courts. But nonetheless, parties very often do seek to adduce evidence of law by way of legal experts. In treaty cases, ICSID cases or UNCITRAL, etc., cases brought under treaties, it is extremely common to bring forth legal experts, very often experts on the proper operation of various concepts in public international law, umbrella clauses or whatever the case may be. Now, I think depending on the tribunal, that's not always necessary, but certainly it's what parties seek to do. I think in commercial arbitration, it's less justified. The starting point should certainly be that all questions of law are questions of submission to be made by one or more counsel, including counsel, of course, qualified in the relevant system of law, if the parties wish. There is, I think, a narrow role for legal experts where the point of law is really obscure or unclear. And I mentioned at the outset that I've been involved in a case in Seoul where that was certainly the case, where the case arguably turned on a point of Korean law, which was, in all honesty, extremely uncertain, where there were conflicting decisions of the Seoul, of various courts, but particularly of the Seoul District Court. And there was a question of effectively what was the correct answer to this point in circumstances where the Korean Supreme Court had not yet pronounced upon the point. It wasn't open, or the tribunal decided that it wasn't open to them to simply stay the proceedings and wait to see what the Korean Supreme Court would say about this point, when invariably it reached it. So in that case, there was a very useful assistance from Korean professors of law to seek to educate and persuade the tribunal on this point. But that, I think, is a relatively rare case. That's all I wish to say at the outset. I'm sorry I have, as usual, slightly overrun my time. Thank you.
Thank you, Matthew, for your presentation. Matthew mentioned the tick and tat, which took me down memory lane. I remember working on an arbitration of a construction dispute where just because of that tick and tat process, we ended up having over 10 experts, testifying experts on each side, which was a huge burden of cost and time. So yeah, I do also agree with Matthew that it could become a very problematic issue. Matthew also quoted the ICC Commission recommendation that there should be a presumption against adducing expert evidence, but there are often some cases where the whole dispute boils down to a battle of the experts. And some firms employ strategic hiring or making inquiries to top experts to preserve them early on or ensure they're conflicted out of the case. I just want to open up the floor to Jane and Myung-Ahn and of course Matthew on whether you have seen this practice and what the issues may be on conflict of interest. Should I start with you, Jane?
Yes, certainly. I mean, I practice a lot in the construction sector, and so we will often have many experts appearing. Though I think to some extent there is a bit of a pushback in that, because a lot of law firms, I think, and I used to work in law firms before being at the bar, I think you see this quite often because some of the large construction cases are so fact heavy that quite often it can be easier to some extent to push the facts onto the experts, especially the delay experts and things, and even a lot of the quantum experts in construction, and that you'll find that they're actually managing the facts rather than spending more time doing that than what they're actually there for, which is to give their opinion on specific issues. And so I think there is sometimes a bit of a pushback of that, and certainly I've seen that, say, in delay, because some of the delay analysis you see on very large mega projects now becomes almost meaningless because the schedules are so large. They were never created for the purposes of doing delay analysis. They're created for the purposes of project management. And people essentially are trying to use these schedules for purposes they're not really intended. And there starts becoming really quite a divergence between reality and then what the computer says. And I think at that point, actually, people are saying, actually, let's strip out a lot of that expert evidence and get back to, the facts. Delay is caused by factual things happening, actually hearing from the people who were on the project at the time, the project managers, the site managers, etc., and having them explaining the impact of certain events on the project, I often feel is more persuasive to the tribunal than having an expert who's presenting this very complicated sort of computer-based delay analysis, which doesn't really tell you it just tells you what the computer says the answer is. It doesn't tell you what actually was delaying the project at the time.
Thank you, Jane. Yes, ma'am.
Yeah, thank you, Kelly. I do concur with the general assessment by our panelists. I think by way of just example, the timing and the scope of the expert evidence that you adduce for the tribunal would matter as a matter of strategy and quite frankly, as a matter of maximizing the efficiency in the best interest of the client. However, as Matthew and Jane helpfully noted, there are certain areas and sometimes evolving technological areas in which experts' opinions do matter and depending on the stage at which that opinion becomes vital, it's going to be a matter of collaboration between the clients and the counsel to manage and adjust the scope and the technological issues that will be at play. By way of example, I am thinking of the role of cryptocurrency, for instance, how that becomes relevant in terms of trading, how that becomes relevant in terms of technological glitches or room for manipulation by a certain party. It can become an issue, and along with some of the traditional classical areas that we've seen, shipbuilding disputes, construction disputes that are obviously one of the predominant areas in dispute resolution and international arbitration. It's going to be an interesting arena for us to observe in kind of seeing the recent trend and how they can become relevant in strategizing and narrowing the scope or expanding the scope depending on the nature of the case and disputes.
Thank you, Myung-Ahn. While I have you on, I think it would be helpful to provide the viewers on insight on your experience working in Korea for Korean clients. You have worked on various types of international disputes for Korean clients and foreign. And when you're working with the Korean client or against, and you've employed experts, are there any distinguishing factors that you have come across that relate to Korean party related cases?
Thank you, Kelly. I mean, there is an old proverb in Korean which says, 가랑비에 옷 젖는다. And roughly translated, it means, incremental, subtle errors that remain undetected can lead to catastrophic results. And so in terms of dealing with arbitrations and expert evidence, it does bear certain relevance as well. In civil jurisdictions such as Korea, we've seen, a number of commonalities across the board. Just because we are basing our arbitration in Korea or seat of arbitration in Korea, or even appearing before the tribunal comprised of civil law trained members, it doesn't necessarily mean that there will be a drastic shift in the way we formulate and present the facts and the evidence. However, as you helpfully noted, Kelly, there are certain subtleties or cultural dichotomies that can come into play. For example, we've seen certain characteristics amongst the civil law trained practitioners. There's generally an orientation or propensity, if you will, to be statute driven. And so they seem to place more credence on the regulations and the legal principles stipulated by domestic codes, as opposed to, say, US litigators who may be more used to individual facts-driven case law or precedents. And then I've also personally seen some deductive way of analysis or framework of analysis where civil law arbitrators may tend to approach a legal problem by starting with a general legal principle and then applying that principle to given facts. They are likely to be less used to or less familiar with aggressive document production requests or adversarial cross-examination styles. And so it's difficult to say which one of those styles would prevail or is more preferred. But being aware or well aware of these subtleties or cultural differences could be quite helpful in addressing your disputes in the interest of your clients.
Thank you, Myung-Ahn. That was really helpful. We have one of our viewers who had put in a comment regarding this presentation. I'll read that out to you guys. Controlled by the tribunal of the experts, he presented two ideas. One, do not permit expert evidence with first exchange of memorials, pleadings, so that issues can be identified first. And second, to use protocol of HKIAC to narrow expert evidence by reference to issues validated by tribunal and only in reports exchanged after without prejudice discussions between the experts, so that they are focused from the outset on areas of disagreement. I think these are really great 2 points. Any comments on this, or have you had run by a tribunal who employed these mechanisms, and did you find that persuasive or effective?
Absolutely.
Sorry, go
Go ahead.
ahead. No, you go first.
Thank you. I echo that view. At the end of the day, it's not about academic debate. It's about presenting a practical resolution to the dispute that's on the table, and setting out at an early stage what type of questions and at what stage do you have your dispute addressed by the expert, and expert opinion could be quite critical in making sure that you have the efficiency necessary, and that you're not really creating unnecessary delay in proceeding with the arbitration process. With that, Matthew, I could also defer to you.
Yeah, I'm violently agreeing with you, and indeed the question, or the 2 comments in the question or the comment, I think were extremely pertinent. And I have seen a couple of cases where tribunals have done that. So essentially they order an exchange, if you like, a pleading exchange without evidence, or certainly without expert evidence, but a pleading exchange, the purpose of which is really to help to identify the issues. Now, sometimes tribunals may feel they can do that by reference to the request for arbitration and the answer, or the notice of arbitration and the answer. But in complex cases, of course, that won't be possible. In most cases, that won't be possible. So they could then, and sometimes do, order an exchange, effectively a sort of a bare bones pleading of the issue, so they can then identify and properly control expert evidence. But it rarely happens. And it also takes quite a brave tribunal to say to a party, no, you cannot have expert evidence in that area.
Yeah, I mean, I think certainly my experience is more the tribunal don't let the evidence in, but they may express a view as to whether it's necessary. And if they consider it's unnecessary, they'll either give it very little weight, or that it would have an impact on costs allocation. So they might, I've certainly seen tribunals early on say, do you really need, for example, a local law expert? Because of course they know, as Matthew said, the moment one person turns up with a local law expert, the other side sort of feels they have to, because you don't want to be in the position that, you don't have an expert speaking on a particular topic. So I've certainly seen tribunals do that. But also what's important is then when they get to the end, but they actually they do what they've said. And if you didn't need the expert evidence, that they don't award costs in relation to that.
Thank you, Jane. This is a great topic, a lot of great discussions going on, but due to time, I'm going to go ahead and move on to Jane's presentation. Jane will hopefully cover the cross-examination of expert witnesses in international arbitration. Jane, I pass on to you.
Great, thank you very much. So if we could have the next slide, please. And I put this slide up because I think this quote's quite helpful, because be it even if you're an experienced counsel, or maybe if you're a junior associate being asked to help prepare cross-examination for the partners you work for, it can be a little daunting if you're thinking, well, I'm just a lawyer, and suddenly I've got to cross-examine or prepare cross-examination for maybe one of the world's leading experts on a very technical issue. And so something that I often would say to the juniors was, remember this, that the expert is someone who knows more and more about less and less, until they know absolutely everything about nothing. And I think that's it's quite important to remember that. Yes, they might be an expert, but in most arbitrations, the really important issue where their opinion of the expert might turn the case will be on a very, very discrete issue. So you need to master their expertise to the point you can cross-examine the expert credibly before the tribunal. In most cases, in relation to a very, very small issue as well. So it's not, I need to know everything about satellite technology. It's, I need to know about this one particular valve or something. And so that makes your job a little bit easier from the beginning, when you're thinking, how do I approach that? And then if we could have the next slide, please, Kelly. And then just a few basics. Now, some of these basics apply whether you're cross-examining fact witnesses or experts. But I think it is important to think when you're cross-examining the experts, In international arbitration, we'll typically be working on a chess clock. So you'll have a certain number of hours allocated to present your case, to cross-examine people. And typically in international arbitration, our hearings will be very short. I mean, as in construction, a case that might sometimes sit for 12 weeks, maybe even 12 months in court, you'll often do in 12 days at most in arbitration, which means again that you won't be cross-examining experts for weeks on end. You'll be cross-examining them for maybe 2 days at the most, and quite often you'll only be cross-examining somebody for a few hours. And in reality, in a few hours, there's only so many issues you could cover. So you need to focus your time very carefully. But again, going back to that, how am I going to get on top of this expertise? You only need to get on top of the particular bits of the expertise that you're going to be focusing on for a relatively short period of time. I also think an important issue is whether the experts have been in the room during the hearing or not. And to some extent, that will depend on the type of expert. I think a legal expert, it probably doesn't matter because they're just giving the evidence on the law. But if you've got, for example, a delay expert or some other type of technical expert or a quantum expert whose evidence very much relies on what are essentially assumed facts at the time that they prepare their opinions, it's important, in my view, that they've heard the evidence and ideally actually physically heard it rather than just read the transcript, so that by the time they come to give evidence, you can say to them, well, you will have heard Mr. So-and-so admit that in fact there was only 10,000 tons of feedstock available a month, not 100,000 tons of feedstock a month. So you need to adjust your valuation or things like that. So I think it's quite important that they are in the room. And certainly to the extent that I'm able to control the process, either as counsel, making submissions to the tribunal or in the tribunal, I would normally insist that the experts are actually in the room and hearing the evidence in person. I think another issue is whether they're going to testify under oath or not. And traditionally, I'd say that experts generally didn't testify under oath in international experience, in international arbitration. That was certainly my experience at the beginning. Now, I'd say it's more common that they will testify under oath. And I think that's quite sensible. It just, again, makes everybody more aware of the importance of what they're doing. Because of course, in international arbitration, and one of the joys of international arbitration is it brings people together from multiple jurisdictions, multiple cultures and multiple backgrounds. And something that might seem completely normal to me or to Matthew might seem completely alien to somebody else who's come from a different background. So just making sure that everybody's under oath and testifying, I think, can be quite helpful. So if we could have the next slide, please. And there's one more slide on sort of the context. And again, you need to be careful on your particular jurisdiction. But unlike many courts, where there's a very strict rule, certainly in common law courts, that you should put your case, as it were, to a witness during cross-examination if you're going to be challenging their evidence in your closing submissions. You don't necessarily have to do that in international arbitration. So I very much take the view out, most of the time, I'm only going to be cross-examining somebody on a point if doing so is likely to improve my client's position. You do need to, I do say check your jurisdiction, because there have been some cases where courts have set aside awards or sent them back to the arbitrators, where a particular issue upon which a tribunal found a point hadn't been put to a key witness or expert. So you do need to be careful on that. But generally, you can choose the areas you're going to cross-examine. And for me, I'll normally be thinking, every time I ask someone a question in cross-examination, I'm giving the other side 2 or 3 opportunities to improve their case. So I'm constantly thinking, sort of looking at things, thinking, okay, here's my case, there's their case. If I ask this question, is mine going to go up, or is theirs going to, and theirs go down, or is there a possibility that their case will go up, their case will improve in front of the eyes of the tribunal? And they might give a good answer to the question I've asked, or they might be asked questions in re-examination, or they might, for tribunal, you might have piqued for tribunal's interest, because they'll think you've only got a short period with this expert, you've asked them a question about this, you must think it's important, therefore they'll ask some questions as well. And each time they might be able to improve. If I could have the next slide, please. So then when we're looking at what do you need to achieve during your cross-examination, so I'll always be looking at this both in relation to the witnesses of fact and the experts in parallel, because of course it's that point, your experts, and particularly your technical experts, they're giving evidence based on assumed facts. So you might need to, you'll need to attack those assumed facts that are important to them when you're cross-examining the witnesses, a fact, but also for the experts, because I tend to do commercial arbitration, my main focus is where is the money? If I was doing public international law cases, I might not be so worried about the money and I might be worried about matters of principle, but in commercial arbitration, it's almost always about the money. So I'll be saying, where are the big numbers in this arbitration coming from? And that's where I'm going to focus on my expert cross-examination. So if I could have the next slide, please, Kelly. So again, looking at what topics I might have to cross-examine, I'll ask my own witnesses, my expert, the client, for where they think there are issues that I really should be asking. Do a lot of research into the background, and of course now with social media, with LinkedIn and things, there's so much more research we can now do in relation to the background to our experts than we used to be able to do previously. And then in particular for experts, I'll be looking at industry professional literature. Experts will often adopt a particular methodology, a particular valuation approach, or a methodology to assess delay or to measure the quality of feedstock or whatever your arbitration is about. And I'll be looking, is the approach that they're adopting recognized, or have they just come up with something of their own? Is it approved? It might be that it's an approved approach, but it's not appropriate in the particular circumstances of that case. And also then very important to check whether the expert has actually done what they've said, because you'll often find an expert saying, I've adopted this approach, but actually when you go through the detail of what they've done, they haven't actually done that. They've done something different, or they've maybe done it incorrectly. And so I'd say that's why I have my check, and check again. Keep on checking. It's the detail. You can often undermine these very technical experts in the detailed schedules to their reports, because that's where you're most likely to find the errors. They've got the wrong dates, the calculation's been set up wrong, all these other issues there that you can find can be a very fertile ground for areas for cross-examination. And it's also very difficult, I find. I know I'm an accountant as well, but it's very difficult for a quantum expert. If you can identify a few errors in their schedules under cross-examination, it's very difficult for them to be able to say on the hoof while they're in the testifying what the impact of correcting those errors would be to their overall valuation. You can just say, look, it's just not reliable what they've done, would be the ultimate submission you'd be going for under that type of cross-examination. So if I could have the next slide, please. So this slide just summarizes the types of witnesses. And here in particular, we'd be looking at the right-hand column, the experts, and what are they actually testifying on? So you've got your legal experts, evidence of the relevant law, and your technical experts, as I said, it's their opinion based on assumed facts. So I think that's always important to have that in mind when you're thinking, what am I going to cross-examine? Because that's really what they should be focusing on. And as I said earlier in the comment in the panel discussion just now, you'll often find that they talk about a lot of other stuff as well, but certainly on a strict view, that's not really within the parameters of what their expert opinion should be. And if we could look at the next slide, please. And so I now have the next two slides, just have a sort of quick checklist that I often use when I'm preparing a cross-examination or asking a junior to help prepare a cross-examination of areas that I might be going to cross-examine on. So you've got the first one is general credibility. Do they have the right qualifications? Do they actually have the qualifications they say they have? It's surprising the number of people who lie on their CVs that they submit in arbitrations, and you can go away now. It's often relatively easy to check, did somebody actually really have the degree that they say they have, and things. You can do that check. Also their experience, because for me to be an expert, it's qualifications plus relevant experience. And one thing I'll see quite often now is that a lot of people will have an awful lot of experience working as an expert, not that much experience in what they're testifying on. And so I quite often spend time getting to understand exactly what their experience has. I mean, to take an extreme example, I was cross-examining someone recently who'd been put forward as a technical engineering expert. His CV just looked a little bit odd, and we were able to get him to admit that in fact he only had 3 months experience working in the field in which he was purporting to be an expert. And I actually, at that point, I'd made the decision, I checked with the client, I made the decision, I wasn't going to cross-examine him at all, because I was like, you're not an expert. I'm not going to waste, X days of my life cross-examining you when you have no real value to add to this arbitration at all. You've also got sort of undisclosed conflicts and things like that can be important as well. But I always think that general credibility issue, you do just need to keep an eye on the tribunal, because you're sort of playing the man rather than the ball in some sense. Some tribunals like that. And if you get some big hits, it might mean that you actually say, I'm not going to cross-examine this expert at all, because they're not really, or they'll be what I would call an expert in commas rather than a true expert. But you'd see that. If it's a legal expert, and moving on to the substance, I'm often very light in cross-examination of legal experts, unless they're clearly wrong and clearly ignoring precedent. I would generally be light and leave it to the tribunal. I find the tribunals often actually are more interested in asking questions of the legal experts than hearing cross-examination. So I don't tend to cross-examine my legal experts extensively, but I may do. It would depend on the particular case. If we could have the next slide, please, Kelly. And then looking at the next slide, I'd say here for technical experts, which is really the phrase I'm using for anyone who's not a legal expert. So as Matthew said, these might be the accountants, the architects, the engineers, the medics, all sorts of professionals who are real experts in that process. So again, you see at the top of this box, I've got that general credibility that I might go for. Then I'll look at the substance, and I think of this normally in two ways. So methodology and assumed facts, because that's what these experts are doing. They're choosing a methodology and they're applying that methodology to the facts that they are assuming. So you can attack them in both of those at all. Now, I'll find quite often people will focus on the assumed facts. I think it can be easier because you're not really engaging in the expertise on the assumed facts. So if you're maybe starting out in cross-examination, that might be an area to focus. If you can demonstrate that they have assumed that something happened on a particular day and it actually happened a year later, or that as I said, they've assumed that there was X amount of feedstock and it was a tenth or whatever, that can be a very good way to undermine their opinions. But I think it's also important, if you can, to step up and cross-examine on the methodologies as well. And that can become more difficult because it's almost engaging sometimes in some sort of almost a debate with the expert on the methodology. Why did they choose that methodology? Is it really appropriate? And in particular, have they implemented it? If you have the confidence to get right into the detailed schedules behind the expert reports and demonstrate that whatever they've said they've done, they've not done it, or they've done it incorrectly, their spreadsheets don't work or what have you, you can do huge damage to the expert. So it's sort of a slightly more advanced cross-examining, but it can be very effective when you do it, because it's very difficult for experts to come back on that when you've clearly demonstrated they've made errors in their reports. And if we could just quickly go to the next slide. So generally, I've now got a few slides, and I'll just go through these quickly because I know we don't have much time, but you'll have the material for later. Really, of sort of the type of questions you might want to ask in relation to each of those boxes we were just looking at. So here, in relation to expertise or credibility, are they independent, override duty? Conditional fees. I ask almost every time about conditional fees to the experts. Every time I think, maybe I won't bother this arbitration because I've asked for the last 10 arbitrations and everybody has said no, they're on a fixed fee or they're on an hourly rate. I think I'll just ask once more, and the expert will actually admit that they are getting paid depending on the outcome of the arbitration, which is frankly astonishing. I mean, they cannot possibly be giving independent expert evidence, but I think it's worth asking. It only takes 1 minute and you can move on quickly otherwise. Also, the fees generated by the client or law firm can be an issue. As Matthew said, as lawyers, we often have our favorite experts, people who will deliver on time, a good quality report. It's tempting to use them again and again and again, but you do have to be careful that might be seen to start impinging on their independence. the next bullet point, it can be very useful with a lot of the professional experts, because most professions have very detailed technical requirements as to when you are testifying in litigation or in arbitration. You know, things you must do, things you mustn't do. And so it's a very easy question to say early on in the cross-examination, so of course you've complied with your professional obligations, haven't you? Yes. You know, and then later on demonstrate that they clearly haven't, because it's a very easy points to make on those, and it can severely undermine their credibility. Other points that I'll look at, and if we could just go to the next slide, Kelly, please. So moving through the topics, you know, understand, quite often you'll find experts who simply fail to understand what they're there for. Some experts will actually think they are the arbitrators, and will make findings as to who's responsible, you know, liability, you know, that so-and-so is entitled to an extension of times. If you're doing construction, so-and-so is entitled to payment of this money. You know, that's not what the experts are there for. Where they've done that, you can clearly demonstrate they've not understood their role. But I'd say, I think you sometimes have to be a little bit careful, because you might have an expert who's not actually been an expert before. He's a genuine expert in his field, but hasn't been a testifying expert. So doesn't maybe understand, or has been badly instructed by a law firm who didn't really understand, but their underlying substance of what they're saying is okay. So it's sort of a matter of judgment, how much you might go in to attack an expert on that process. And then again, looking at that basis of opinion, this can be a very easy and fruitful area of what information was made available to them. Some instructing law firms put very limited information in front of the experts, because they know if they gave them the full documentary record that they would come up with an unfavorable finding. So then it can be a very easy way to undermine the credibility of the expert if you can keep showing them documents that either they've never been shown before and really should have asked for because they're obvious documents, or the documents that were on the record and they've just chosen not to look at or mention. So that can be it's very painful for the experts. You can go through and you can do quite a lot of damage quite easily. And again, without even really having to engage in the expertise. So you're not having to worry about the fact that this person, you know, is the world's leading expert. You're just demonstrating that they haven't been thorough and done their job properly as they went through. And then I think my time is pretty much up. So I would see there are a few more slides, but I will leave those and you can look up. I know Kelly will be circulating the material, but I think for timing perspective, Kelly, I better stop and let Matthew and Myung-Ahn have something to say on cross-examination as well.
Great, thank you, Jane. As Jane has mentioned, this webinar will be recorded and we will be putting this up on the website. We will not be providing these presentations online, but anyone who be interested in getting a copy, please do not feel free to contact me separately. As for the presentation, it was very informative, Jane, and thank you for that. I want to start off the panel discussion with an observation. Expert decision is often based on documents, materials, and evidence made available by the parties. Having the experience of working with a Korean company, I can say that there are definitely differences in company culture, practices, and what constitutes as a norm. Jane had touched on this in her presentation, in not only document retention, but accounting practices, record keeping, to just name a few. So I have often considered knowledge and experience of working with a Korean company as an important factor to consider in selecting a party assisting expert. Myung-Ahn, this experience and choosing an expert, have you dealt with this kind of concern?
Thank you. I think that's a very helpful question. I think if I may rewind a little bit, it does provide you with certain room for pause when you deal with different entities and companies with their own internal procedures and a data bank and whatnot. But I think more often than not, and especially during these days, the fundamentals and the fundamental widely shared across borderlines, nationalities, and it may sometimes or to the relevant industry specialized sector.
Sorry, Myung-Ahn, you're breaking in and out. Can you just repeat that one more time?
Yes, can you hear me now?
Yeah.
Okay. I think we were supposed to talk about, the technological issues and the, pros and cons of VC for, having a hearing later on. But I think it's a good example of demonstrating what kind of challenges we may have in having VCs in turn. But, just go back. I was just hoping to address the fact that sometimes, and more often than not, during these, times, national borders matter less, as opposed to the particular industry or the sector of your client. If we were, for example, dealing with a Korean game company, IP company, dealing with a dispute or intellectual property dispute against alleged, breaching party of the license agreement, you can count on your client to have an extremely detailed record keeping process and state-of-the-art technology to retain and record contemporaneous evidence. Similarly, in trading or financing districts, I think there are certain global standards, and unless you meet those standards, you are not going to survive in your own industry. So barring the arbitration or litigation or mediation and whatnot, we've seen some fundamentals that are quite common across the board. But obviously, you sometimes would need to have a little bit of a hand-holding process for your client. Sometimes it is the very first arbitration or even litigation for your own client, and they are not necessarily familiar with document retention process or the requirements thereof. And so the standard document retention request and guidelines are obviously going to be provided well in advance. And being very keen of the cultural lack of familiarity with the adversarial process, especially the arbitration process on an international level, could be quite helpful. I think that's a very poignant and relevant point to make. And thank you for raising that.
Thank you, Myung-Ahn. Matthew, would you like to chime in on the cross-examination of experts topic?
Just to, I very much agree with what the two speakers have said. I think particularly what Jane was saying, one needs to, there's a pressure upon you as counsel when you're facing an expert who has put in 2 or 3 reports totaling 400 or 500 pages to launch onto some enormous cross-examination. Very often there may be indirect pressure, or direct or indirect pressure from the clients in that regard. But as Jane was saying, one needs to focus very, very carefully on what one's trying to get out of the expert. Particularly in the context of arbitration. And of course, as Jane says, you play the person, i.e. the tribunal. What does one think the tribunal needs to hear from? There are, one can, if one is trying to be too cute and going too short, one can be tripped up by the point that one hasn't put a so-called critical point to an expert and is therefore deemed to have conceded it or admitted it. And whether that point gets traction depends on tribunals, but also ultimately depends on the courts at the seat in most places. But generally, the overall point is, don't feel that you need to put every point to an expert, and a 500-page expert report doesn't necessarily mean that you will get or need to cross-examine that expert for 3 days.
Great point. Thank you, Matthew. We will then go ahead and move on to our next speaker, Myung-Ahn. She will be presenting on the role of expert witnesses, their credibility and implication of an important case. Secretary of State for Home Department. Thank you, Myung-Ahn.
Thank you, Kelly. Thank you very much. And thanks again to Kelly, the HKIAC, and everyone, frankly, who's attending today at an early or late hour, depending on where you are. Today, the sequence of my presentation will proceed as follows. Next slide, please. It will first address the background, some of the basic background information pertaining to international arbitration involving expert witnesses. Secondly, I'd like to relay some of the implications arising from the recent case of MN versus Secretary of State. That's the 2020 case from the English Court of Appeal, with a view of addressing the implication, particularly on the credibility of expert witness evidence. And finally, I'd like to share some of the practical considerations, takeaways, or observations, and open the floor for the questions as well. Next slide, please. So just by international arbitration, as you are well aware, it incorporates a number of legal cultures, including Anglo-American and common law system. But the system of assessing, expert witnesses may share some different dynamics, say, compared to the traditional court system. I am Korean American, so part of my training is in the US court. And in terms of US court litigation, you see witness evidence, coming from direct statements from the witness on stand and during trial. And it is heavily regulated by the rules, and leading questions are strictly limited in most of the cases. So prior to giving live testimony on stand, each witness in US court litigation would be subject to a process called deposition by the opposing counsel. And the purpose of that process is to basically help flush out the material issues and contents of what that witness will say on the witness stand during the trial. For further questions, the opposing counsel has to put on the same witness on direct examination of his or her own case, because unlike in international, opposing counsel may cross-examine witnesses only on the matters that had been addressed on direct examination during that trial. By contrast, on the level of international arbitration, direct witness evidence comes from statement. And for expert witnesses, it's going to be provided in the form of expert reports. And obviously, there will be less strict prohibition on leading questions during cross-examination. And as for the direct examination, it will be limited to a very succinct affirmation of the written statement for witness. So by implication, due to this dichotomy between what the court litigation system as opposed to international arbitration, in the latter case, we see a wider discretion and less prohibition on the scope of questions during the hearing. And naturally, as Jane and Matthew had helpfully pointed out, the ability of the counsel to bring out and appreciate the nuanced jurisdictional differences and to effectively examine the witness on cross-examination will be quite critical. Next slide, please. Next slide, please, Kelly. I think we may address the import or implication of the MN versus Secretary of State as part of our presentation today. Now, against the backdrop of what we've just addressed, it is quite helpful to consider the implication of MN versus Secretary of State, because it's a decision that did directly address the expert credibility and the framework of analyses that should be adopted by the fact finder. And in that case, it was the authority of the Home Office, which, as I understand, is akin to immigration authorities in other jurisdictions. And that framework analysis was to be addressed in deciding whether someone some applicant is a victim of human trafficking, qualified to receive government aid and support. It did address, the proper approach to expert evidence and reinforce the principle that the fact finder should give credence and holistic review of the decision-making process to ensure that expert evidence is properly taken into consideration. The case also alerted to the risk of unqualified fact finder in speculating about issues requiring expertise. And in that case, the issue was about the medical causes of PTSD, post-traumatic syndrome. And the role of expert was also part of the analysis stipulated by the court in that case. It did basically give credence to the fact that it's going to be inappropriate to discount the value of the expert evidence on the basis of a separate incidental set of background facts. And in that case, it was related to some inconsistent facts or failure to disclose some facts by the claimant or applicant. And it was actually indicated as the case that it's not the role of an expert report to undertake some kind of assessment on the applicant's factual account or accounts that had previously given to the judicial process. So in sum, I think the case is helpful in highlighting the principle that there is a unique realm of expertise and respect to be provided to the expert evidence, and the credibility and weight to be given to the expert opinion cannot be discounted in a similar manner that's akin to the standards that are applied to, say, a factual layperson's witness. I personally saw another implication of the case. It basically reconfirmed the unique nature of the expert evidence. And I think during the earlier part of our seminar, our panelists did allude to the requirement for the expert to prove his or her independence and the track records that are going to be assessed by the counsel in advance or even by the opposing counsel on cross-examination. And so it's relevant to take a look at or even revisit some of the content criteria set out by the IBA. And it does provide that each expert witness statement or expert report must state, the description of the instructions given, the methodologies or assumptions or facts that are provided in order for that expert to provide that expert opinion, and a statement of independence as well as affirmation of genuine belief are all not just perfunctory mechanisms, but those are the ones that are specifically catered to ensuring that the level of credibility is continued on a rolling basis. So next slide, please. So then it brings us to the next step. What are then the practical considerations and takeaways that we may consider against this backdrop of witness credibility, also in line with the recent ruling? The first item would be establishing credibility of your own expert witness. And there have been a number of cases or war stories that we have heard, and they're all very helpful. And as indicated, in terms of your own expert witness, unlike in the court litigation context, the direct examination of your own witness will be quite limited. And so the content of your expert report, the written report to be provided by your expert report must be well prepared, verified, and substantiated by reasonable assumptions, accurate methodologies, and contemporaneous evidence supporting what is being said by the expert. Those are quite basics, but then they are quite key in terms of ensuring that you obtain the result that your client deserves. In terms of preparing for hot topping, I've kind of thought about the possibility in the context of establishing credibility of your own expert, because it does provide you with your case and with your expert with an opportunity to have the experts from each side confer with each other on a particular issue of dispute and narrow down, for the sake of efficiency, narrow down the issues of genuine dispute. And it's quite effective in terms of enhancing the timeline and efficiency of the case. And it oftentimes encourages the party to comment directly on the specific methods and comments, and just prevent each party from beating around the bush and help save the time. One caveat, however, is that this hot topping methodology is not without any risk. Depending on the case, you may want to consider the nature of the evidence, as well as an opportunity to anticipate and prepare every possible question that can come in advance. In terms of the second item, challenging credibility of the adverse expert, there are available measures to address this daunting task, but it's not impossible to overcome the challenge. First question usually that I look into is the type of the adverse expert you're going to face. There are essentially two different types of the experts that are who are adverse to your case. One would be an expert who's intentionally misleading, dishonest, and then the other type would be someone who is very well-intended and well-meaning, but somebody who's not well-informed and may have based his or her opinion on incomplete or misleading set of assumptions. Now, in terms of the former, it's easier because you basically need to prove the bias of the person with contemporaneous documents and consider the need to assist the tribunal in articulating the reasons behind your assertions. But in case of the latter, you need to expose the inconsistency in the method and the assumptions adopted by that misled or misguided expert. And in order to obtain concession, obviously, you need to have a level of humility because you're not an expert in the area oftentimes, and that expert knows a lot more about that particular area than you do. So in a way, there has to be a practical approach in terms of discrediting that particular witness by showing inconsistencies with prior views of his or her own or other well-established texts or expert reports, oftentimes your own expert report, and obtain admissions on undisputed principles or supporting documents in your own case. Another possible measure would be to obtain concession on the existence of alternative and viable assumptions and methodologies that he may not or she may not have adopted. I've had an opportunity to cross-examine recently a quantum expert as well as a legal expert, and the approach taken in each of those cases differed slightly based on the nature of the questions and disputes given. In case of the quantum expert, you, as indicated earlier, have to admit the high likelihood that the computation of that expert is likely to be quite accurate. Depending on the quality of the forensic test that you're able to conduct, however, the underlying assumptions for that quantum computation could be subject to question. So in short, in testing the quantum expert, it's not usually helpful, based on my experience, to assert against the computation itself, but it may be helpful to agree on the difference in the assumptions or the nature of the assumptions underlying that computation, and lead the expert to concede that if your assumptions were to be adopted, that it'd be logical to conclude that your own assertion or your own stance would be correct. That is slightly different from the approach that I would usually make in dealing with legal expert. Once again, the legal expert is most often than not, he or she has deep knowledge in that particular area of law. And that is a given fact, but key strategy against that backdrop may be to address the difference between the principle of the law that's not disputed and the particular applicability of that principle in the facts of your case. About a couple of years ago, we were dealing with an ICC arbitration in which the constitutional legal principle under Korean law was at issue, and one of the adverse expert witness was a former justice from the Constitutional Court of Korea. So obviously, in terms of expertise, he was going to be respected, but we were able to question whether he would make a distinction between the premise or the type of the statute that was at issue, whether or not it was meilum in se as opposed to meilum in prohibitum. And obviously the latter type of statute would be one that would be less subject to parties' expectation of status quo. And so in terms of distinguishing between the minute nuanced differences and assumptions could be quite helpful. I think in terms of time, I'm reaching the limit, but one final point I wanted to make was in relation to language, culture, and the technology factor in international arbitration. In certain cases, we have an expert witnesses included who do not speak the language that are familiar, that are native language of the tribunal members. And it may be helpful to delineate those differences and cultural nuances and ensure that you are well prepared to provide very competent interpreter and the sequence of that interpretation, as well as the ability to have a neutral checker to provide a very valid process along the way would be quite helpful and highly recommended. In terms of technology, we've kind of seen a little bit of technical glitch, but one just final thing I'd like to point out is it's always helpful to prepare, make sure that you're prepared well enough to know what is going to be happening, and also after that, prepare more to ensure that nothing wrong can happen. So in terms of making sure that your bandwidth, technology, audio facilities are well tested and jointly verified by each party could be quite helpful as well. So that concludes my presentation, and I thank you very much for your time.
Thank you, Myung-Ahn. That was really great points for us to consider. So the final takeaway I got was check, and prepare, right? So with that, I will go into the panel discussion. We have a question by the audience on this, the topic that you have actually discussed. So I think I want to go ahead and kick off the panel discussion with that question. It says, could the panel please try to address particularly to how to manage the single joint expert and hot tubbing experts? Should there be any different tactics when comparing to manage the common general experts, or the same principally? Anybody want to kick us off?
I'm happy to start off with that one, Kelly. I mean, I think the single joint experts are difficult because I think as lawyers, we generally like to exert a lot of control over the case and the evidence that we present in front of a tribunal. And obviously, once you've got an expert who's instructed by both parties, that becomes more difficult. So I think also you just need to make sure, it's very important to make sure that you trust, there's common trust in that expert, and that there aren't side conversations happening. I think that's something that can cause concern. They might not be happening, but if you think they are, that's a worry and undermines the credibility of that expert. I think there also needs to be the ability to agree instructions up front, agree the flow of material to that expert and make sure that that's tracked, because quite often you'll find people send the experts things but don't actually really keep a note of what there are. So I try to have a common secure depository where anyone sends something to the expert puts it in there as well, so that you know what they've had, but also to have the opportunity to see draft findings and be able to comment, because quite often I think that process is misunderstood, because some people will think you're trying to influence or change the expert's opinion. But what will often happen is that the expert is flooded with a lot of information and simply might have overlooked what you consider as an important document or an important fact. And so having that ability to go back to the expert and say, have you looked at this? Have you considered this issue? And being able to do that in a way that's transparent, so both parties see that happening before they issue their final findings, because it can be quite difficult if you're unhappy with the findings of a joint expert. It's quite difficult to sort of cross-examine them. It's a bit like when the party have their own expert. It's sort of more uncomfortable cross-examining and challenging the opinions of a joint expert than it is of challenging the opinions of the party opposite you. So I think you do need to have an element of control there over the process to make sure that it properly reflects your client's case.
Thank you, Jane. Matthew, any comments?
No, not really. I agree with that. I would just say that I think in terms of single joint experts, or just to be clear on the terminology, tribunal experts or tribunal appointed experts, as I said at the outset, is that I actually think there's more scope to use them than they actually are used. I think tribunals actually shy away, certainly in non-construction cases, from using them in circumstances where actually a timely engagement of a tribunal expert and then properly instructed really can help to narrow issues.
Thank you, Matthew. I totally agree with that. We have a comment here from an audience who have mentioned that he has sat in a hot tub and found it very effective for two reasons. Week-long negotiations of the agenda to be discussed in the hot tub effectively focused on the case, on the key commercial issues, and two, the tribunal had the opportunity to ask their own questions. And his question after his comments were, why are hot tubs not used almost always? I'm sure there's a preference and there's issues concerned around hot tubbing. Myung-Ahn, do you want to take this on?
Sure, I think that's a very good question, and that does give me, a bit of existential angst as well. I think may relate to the very fact that arbitrations differ on a case-by-case basis, and sometimes before a party decides to go ahead with this hot tubbing, one may consider the strength of proceeding with that process. Obviously, we've talked about efficiency, but another strategic decision factor is the very fact that the tribunals remember the answers to the question that they asked. And so if you allow this hot tubbing process and let the experts explain in their own words to the tribunal as to what this distinct specific issues in dispute may be and how they may be addressed by each expert and reconcile those differences along the way, it can be quite a powerful tool. But at the same time, it just depends on the nature of the disagreement and the scope and the issues that are on the table. And it's sometimes difficult for either or both parties to proceed on the basis that the risks outweigh the benefits, or vice versa. It's going to be relevant to the strategic decision.
Thank you, Myung-Ahn. Jane, would you like to comment?
Yeah, I was just going to say, certainly my arbitrations, and maybe that is just because they tend to be the more construction or very technical arbitrations, we almost always have a hot tub. But I'd say what would happen is it's normally there will be traditional cross-examination first, and then afterwards there'll be a hot tub by discipline. So the tribunal will have already sort of had the benefit of the evidence being challenged by counsel, and then they go into the hot tub. And in the hot tub, certainly my experience, and I know there was a question about this, my experience is it's the tribunal who ask the vast majority of the questions. They'll ask counsel if they've got any follow-up questions, but it was very much a tribunal-led process. And I've seen that both from common law and civil law tribunals. That seems to be sort of at least becoming a common practice in the type of arbitrations I work in.
Yeah, yes, can I just add one thing? I think in its original conception, hot tubbing was as conceived by Wolfgang Peter probably 20 odd years ago now. The tribunal was to control the process at the outset. So the tribunal would ask all the questions initially, and then counsel would get to follow up at the end, what Jane and I would say cross-examination right at the end. As Jane says very often now, that what I think Wolfgang Peter would say is that pure order is flipped. So you do cross-examination first, and then the tribunal comes in at the end with its questions, if you like. So claimant's expert is cross-examined, respondent's expert is cross-examined. They both remain sequestered, or they both remain there or available, if you like, and then the tribunal come in with their questions. But I think if you ask Wolfgang Peter, he would say, no, that's not right. The tribunal should be properly prepared. They should take control, and they should do it all themselves initially. And I don't want this whole process taken over by common lawyers trying to cross-examine. I may be putting his words in his mouth, but that's what I think might be said. I'm not saying which is right or wrong.
Thank you, Matthew. This is a very interesting topic. I think hot tubbing has been more frequently used than in the past, and it's definitely an interest area. We have a very engaging audience today, and there's lots of questions, but due to time, I will only cover a few. My apologies for that. One of the questions we received was, for example, when you are a claimant and you engage both a dirty expert consultant and a clean expert witness, should interaction between the dirty and clean experts be avoided in order to avoid allegations that the clean expert is biased or tainted? Matthew, could you kick us off?
Kelly, sorry, I lost you. Can you just restate that? I heard only the very first part of what you said.
Sure, let me repeat that. When you are a claimant and you engage both a dirty expert and a consultant, a clean expert witness, should interaction between the dirty and the clean experts be avoided in order to avoid allegations that clean expert is biased or tainted?
I think not avoid. I don't think it needs to be completely avoided, but you just need to bear in mind that the testifying expert, the expert giving evidence, probably will be asked to disclose the full basis of his or her instructions. And that's, of course, not just a letter that's often finalized the night before the expert report is signed saying, you are instructed to opine on the following 9 things. But in theory, not more than in theory, in practice, anything else that has been sent to or imparted to the expert that might affect his or her opinion. So if your testifying expert has received a lot of information from the consultant expert or dirty expert, or had lots of meetings and so on, then that's potentially at least fair game for cross-examination.
Thank you, Matthew. Jane or Myung-Ahn, any comments on this?
I'd say it's sort of slightly on a slightly related topic. I mean, something that I've been trying to do, both asking as counsel or ordering as arbitrator, is, as I said, to have a common depository of information that's provided to the experts, so to the testifying experts. Because one of the issues I sometimes have is that you'll get one expert who doesn't mention a huge amount of information that's been provided to them. Well, in my view, that for the experts, one really need to have parity of information. So whatever non-privileged information has been provided by a party to an expert, they clearly thought was potentially relevant, and therefore it should be available to the experts on both sides. Otherwise, they often talk at cross purposes. So I think, again, that might be one reason for having your dirty expert, who you might show some material to before you then show it to your clean expert, because you'll know that if you show that information to the clean expert, it may well end up on the arbitration record and be fair game for cross-examination by the other side. So I think in that respect, that's where, for me, I would be keeping I would be wanting to keep that barrier of interaction, but actually having conversations and discussions about the expertise. That's one reason why you bring in the dirty expert, because it might be an area that's so technically advanced that you would feel that as lawyers, you can't really engage with that topic properly.
Right. Thank you for that. I think that's a really great point about this disclosure issue. While I have you on, Jane, there's a question directed for you. In construction disputes, can a claims consultancy supply both claims consultants during the project and expert services during a subsequent arbitration? What are the risks in this situation?
This is an issue that comes up all the time, and to some extent it's a bit like having it's the same, similar to the dirty and clean expert, because the individuals who have been acting as, for example, cost consultants or claims consultants through the course of the project are to some extent sort of dirty. They know everything. I think that, so there's that issue, but there's also the independence, and I certainly think it's very difficult for someone who has been working as an advisor, and quite often will have been, these types of experts will often have been advising on legal matters, on strategy, on how the claims are put forward, to then put a different hat on and appear as an independent testifying expert. So I would generally recommend to clients that they don't do that. I think you do need to bring in someone different. That doesn't mean the claims consultants all sort of go away. They can be a very useful part of the team, helping the lawyers with all of the facts and the underlying issues that they'll be very familiar with. So that knowledge isn't lost. But I personally think it's very difficult for them credibly to be portrayed as independent experts later on. Sometimes it's okay, but it will depend on the issues and quite how embedded and involved they were early on.
Right. Thank you, Jane. One last question, and this is from Myung-Ahn. Can you explain in details how to manage the language interpretation challenge? As at the end of the day, the understanding and judgment of two sides argument will be highly based understanding of the language interpretation. But very often, judge and lawyer might not be able to speak the given witness's language. And how can a lawyer and judge know the interpretation is effective? I've actually had this issue come up several times in an ad hoc arbitration in Chile and also in Korea as well with the Korean language. So I'm sure you've come across this issue as well.
Absolutely. I think there are certain unilateral measures you can take, and then you also have the opportunity to consult with the counterparty and seek the order of the tribunal, procedural order, incidental it may be, in advance of the hearing, to ensure that there's not going to be a very profuse objections on mere technicalities. But if there are a very specific material difference in the way the particular interpreter translates a certain term that's key to the dispute, then that's going to be ordered by the tribunal by way of prior procedural order to make that objection. But if the procedural order of the tribunal in advance provides this guideline for each party to refrain from making unnecessary and extraneous objections merely to delay the process or to stall the continuum of the counterparty's examination, that tends to be quite helpful, and we've utilized that in our prior cases as well. I've mentioned some unilateral measures that you can take, and those are basics, such as making sure that competent and neutral interpreters and a list of such qualified candidates in advance so that they can provide qualified work and services on time. You also may need to have some bilingual checker in the room so that the neutral checking system is in play. And in the event there's any kind of objection, that person can step forward and make sure that the tribunal is assisted without unnecessary delay. Oftentimes, it's quite unfortunate, but I've seen some cases where certain counsel kind of utilizes or tries to utilize the language barrier as a way to delay the process, and that should not have a place. And some of the unilateral as well as assistance of the tribunal in advance could be helpful. And it all depends on the specific nature of the, I guess, the case, but there are certain basic rudimentary measures that you can implement in advance to prevent that.
Thank you, Myung-Ahn. You mentioned the checker, and usually I've seen in often all the cases we have the checker on both parties. So the party that employed the expert will have their own checker to make sure their experts are doing it right, and then the opposing counsel often would have their own checker to make sure it's done right. So I guess the job will be on the counsels to make sure that the tribunal is getting the adequate translation, the interpretation.
Right. And if push comes to shove, and if one checker does not really provide credible and accurate interpretation at the end of the day, that can be cross-checked after the hearing, or even, you know, right after the first or second day of the hearing as well. So I think the pressure is on both sides to be accurate and to be forthcoming.
Thank you, Myung-Ahn. That's really helpful. We've went over time. I'm sorry for that, but we've had so many questions and we haven't been able to cover it all. I want to thank you all in for tuning in today and for such an engaging audience. I hope you found the presentations helpful as I did. You always learn something new every day, and I certainly did today. A big thank you to our speakers, Matthew and Jane, who is logging in from London, and Myung-Ahn from Korea. It was truly a pleasure having you all here, and such an engaging speakers and discussion was very fabulous. I will be putting up the recording of today's webinar on our website, as I mentioned earlier. If you missed any part of it, please check it out. We will also be providing our speakers' contact information on our website as well. But you will be able to Google them. Very popular names. So if you have any questions that you were not able to get, please feel free to contact them separately with inquiries directly. And thank you everyone for joining us today, and hope you have a fabulous rest of the day and rest of the week. Thank you, Matthew, Jane, and Myung-Ahn for your presentation today.
Thank you.
Thank you for asking us.
Thank you.
Thanks, everyone. Bye.
Bye-bye.